The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised. Welcome back to your favorite cubbyhole on the internet, everybody. We're back with some more Laura Owens, and I am getting caught up. I am determined to do it before anything else happens. So, our last video was one of Omar's filings in the DVRO case with Mike Marraccini, and then I sort of took my hiatus when it was time to talk about Gingras, and I know he's butthurt. I know that's one of the reasons he named me, or at least I believe that's one of the reasons he named me in his latest escapades with this case. So to make it up to him, and for completion by the time I get to that particular filing, which names me in this channel, thank you, David. I know you watch, or I know Laura watches, one and or both of you, because I see the singular downvote and hundreds of upvotes. So I know someone from Camp Owens or Douche Canoe Land is watching, and thank you for your view, and even thank you for your downvote, because guess what? It all counts. It does, and we're thankful for that, and we're thankful for the excellent advertising and additional PR that we're getting from this channel. It only helps me in my efforts to become a monetized channel, because why wouldn't you? I mean, okay, the 15 cents per video or whatever it is that you might get for being an initial small channel with that capacity, it's really not enough to pay what I've already sunk into doing this work. I've got a few $1,000s into this. So we're a long ways away from even breaking even on this venture, but that's okay. I don't do it for the love of money, because we do okay. We've got enough to pay our bills and live in a decent place in a great city. You have too much money, you just have to give more to the government until you're super wealthy, in which case you get to keep more from the government. It's a very strange system we have here, but never mind. So we are here to read the declaration of David S. Gingras, Esquire. Dingus the Douche Canoe.
The fucking Douche Canoe.
And I need to add a button. I need to add a button that says, Dingus and Pregnancy Faker. We need to add more buttons. He takes offense to that, even though he's called himself that. And so it makes it even more worthwhile. Rosalind Duke had a short, and it's Dingus and Pregnancy Faker, and we need to add something to that. We need to add that to our collection, I think. As do I need to add a collection. I need another song to talk about the DVRO case. I'm thinking maybe the Marraccini Mambo. The Restraining Order Waltz is great. It's lovely, but I want something with a little pep. So whenever we get to these sort of slap fights of lawyering and motion practice and the stupidity of Dingus the Douche Canoe.
The fucking Douche Canoe.
And his attempt at writing motions, which the more I see, the more I laugh. He doesn't realize how funny he is, trying to be serious. And perhaps that's part of his charm to those of us in this community. He just blathers on nonsensically about law that doesn't work. And it's just insane. I use that phrase a lot. I need to come up with more phrases. Leave me phrases down below other than it's insane. I don't know what else to call it, but we know he's a drama queen, and he would probably do well on the stage. But until that bar card gets revoked in both states, and that may be happening, I think there may be some movement. I'm not going to tell you how I know that, but I think there may be some things headed in that direction where Mr. Gingras Esquire's legal career may come to an end. Now, don't take my word for it. Don't take the word of anything in the stars or anywhere else. Just a hunch. But what we're seeing right now, and things declared under penalty of perjury, can only go one way when it is proven to the court that an attorney who practices in both Arizona and California has made fallacious comments and has made false accusations and has made lies and has shared lies to the court. That's easy for a number of us to do that. He's accused lately, and we intend to help out. We do. We like to be helpful here, and we're certainly willing to help those who, like Dumbledore said, help comes to those who deserve it. And it's not David. So there we go. All right. Well, okay, I'm not done yet. And while we're on the subject of David and Omar, well, specifically Omar, let's go here. Let me just state for the obvious record that I have never met Omar. I have never talked to Omar in any capacity. I have never spoken with Omar or about Omar or to Omar, even through a third party. I don't know him at all. The most I may have ever said would be a comment on the Tilted Lawyer channel, just watching some of his videos before he became representation and legal counsel for Mike Marraccini in this case. So David's assertions that Omar's friends are saying things out of turn and their lies about David and Laura is absolutely fallacious, and it is fraud upon the court, and it is a sanctionable offense. And I think with enough reports to the bar, and perhaps this case will be another bar referral, this time in California, for Gingras the Douche Canoe. So he should mind his P's and Q's. Not that I think he's capable, because he can't even be quiet. He can't restrain himself at all to have the right to remain silent. It's not going to go well for him. So again, I would love to meet Omar after this is all finished. I have no communications with Omar. I don't think anybody does right now, because Omar's a decent, ethical attorney. And so there's that separation while he's practicing and working on this case for Mike. And I think Omar will ultimately be victorious, despite the flailing about of someone who decided to jump in the deep end of the pool without water wings. And that's Gingras the Douche Canoe. So he can splash about and scream and cry all he wants, but he's done this to himself. That's what he gets. That's what he gets. I really want to say he just wants to get in Laura's pants. I sort of agree with Laura Knighty on that point. Maybe he has, maybe he hasn't. Maybe Laura just has David's balls in her purse. I don't know. This isn't any statement of fact, but obviously the connections of these two is not wholesome. And perhaps Mommy and Daddy Dearest, that being Jan Black and Ron Owens, were hoping that David would take care of her, as they are sort of falling apart. And boy, all of that video, as I think more and more about it, Jan is not all there, Ron is barely hanging together, and Laura is a mess, and she is just absolutely all over the place. And David tries to be the white knight on his stallion to save Laura and maybe curry her favor. I don't know. Again, that's just that's observations, but his behavior is just unconscionable, and it's illogical, and it's inappropriate, and it's unethical, and it's unprofessional. It's all of those things. It's not normal. This is not normal lawyer behavior by any stretch of the imagination, but he continues to do it. He's inserting his oar into the water with a DVRO case, not representing her, but intervening. Things like an obsessive boyfriend might do. It's bizarre. It is absolutely bizarre. But he still enters the fray, and until the judge kicks him out and keeps him from filing stuff with this case, he's just going to keep running his mouth and getting himself into more trouble. So, with that in mind, with all of that in mind, we will read his trouble. Okay, so this is the declaration of David S. Gingras, Esquire, in support of his motion to intervene, etc. Yes, this is backdated, at least from our perspective, on September 15th, 2025. And since VoiceMod is not cooperating very well, we will make this as straight of a reading as you will ever get from me. That's an inside joke. Figure it out. Okay, let's just get through this because I'm trying to get caught up and more starting to happen this week already. So let's make this a quickie. My name is David S. Gingras. I'm a United States citizen, a resident of the state of Arizona. I'm over the age of 18 years, and if called to testify in court or other proceeding, I could and would give the following testimony, which is based upon my own personal knowledge. I am an attorney licensed to practice law in the states of California since 2002 and Arizona since 2004. And I'm going to give my curriculum vitae because I'm so self-important I have to list everything I've ever done that's important to me, even though it's irrelevant to the court. I graduated from the University of San Francisco School of Law in May of 2000, where I was a member of the USF Legal Review for 2 years. Where does it say he was also editor of the yearbook? I'm an active member in good standing with state bars of Arizona and California. That may change in the future. And I am admitted to practice and in good standing with all the courts that I want to brag about, which are all those. We'll skip those. I previously represented a woman named Laura Owens in case file, Maricopa County Superior Court, Phoenix, Owens v. Eckerd, blah, blah, blah. I didn't get the attention I was hoping because Eckerd is a famous celebrity of sorts, and it just didn't win for me to latch on to that case. We're improvising a little bit. We're giving some editorials. Can you tell? I was initially hired by Miss Owens on March 25th of 24. Shortly after being retained, I learned the case gained a large amount of attention on social media. My belief was that the case attracted attention in part because Party Clayton Eckerd responded, was previously the star of a popular reality TV show called The Bachelor. And I was so hoping that it would make me, David Gingras, even more famous by covering a case to smear him. That's the thought bubble. You know the thought bubbles in cartoons? If this were a cartoon, that's probably what he would say. You know, it wouldn't be a conversation, it would just be a thought bubble. In addition, the case also seemed to attract a large amount of attention due to the unusual allegations it involved. Specifically, Mr. Eckerd accused Miss Owens of faking a pregnancy and then using that as leverage to force him into an unwanted romantic relationship. Because everyone just writes dating contracts, right? I mean, that's a normal thing, isn't it? How is that not an unwanted relationship by saying, oh, having the babies if I don't hear back from you tonight? My work on the Owens v. Eckerd case was primarily limited to presenting legal arguments regarding certain Arizona rules of family law procedure, aka Rule 26. However, in addition to that work, I also assisted Laura pro bono with responding to inquiries about the case from lawyers, journalists, and others. But I won't tell the court that most of them were attack campaigns and vitriolic mudslinging and being a bullying douche canoe.
The fucking douche canoe.
At least those buttons work. One person who inquired about the Owens v. Eckerd case is a lawyer named Omar Serrato. I did not previously know Mr. Serrato, and I first became aware of him on May 23 of 24, when Laura forwarded an email Mr. Serrato sent asking questions about the case. After reviewing Mr. Serrato's questions on May 24, I sent him a lengthy email response. Because I don't believe in self-editing anything, and even my filings get unusually verbose and ridiculous. I believe my email to Mr. Serrato, which was sent with Laura's permission, was friendly, professional, and otherwise routine. I simply answered Mr. Serrato's questions and asked him to let me know if he needed more information. I later learned that in addition to his law practice, Mr. Serrato has a YouTube channel called The Tilted Lawyer, where he publishes videos commenting on various subjects. While I was not aware of this at the time, apparently Mr. Serrato had published a series of videos harshly attacking and criticizing Laura. Dun, dun, dun. If my buttons were working, which they're not at the moment, we will muddle through. Shortly after I sent the email to Mr. Serrato on May 24, I was surprised to see a video he posted discussing my email to him. Mr. Serrato's video was surprising because it was extremely negative, and it contained statements which I believe to be both false and defamatory. Gasp. Among other things, Mr. Serrato told his viewers about my email to him without actually showing the contents of the message. So what? Mr. Serrato insulted me and described my email as extremely unprofessional. Boo-hoo. I believe Mr. Serrato's video overall presented an intentionally false and misleading discussion of both the issues and my interactions with him. Over the last 20 years, I've handled hundreds of cases in state and federal courts across the country that no one cares about, including many high-profile cases involving major celebrities, which I'll never name because they didn't exactly happen the way I want them to. As part of that practice, I've dealt with significant media attention and inquiries from members of the public, including both journalists and other lawyers like Mr. Serrato. Based on my experience, I know some journalists and commentators act in good faith, trying to present fair and neutral stories for their readers. I also know that some journalists and commentators do not act in good faith. Instead, these people generally are not interested in the truth. They are only interested in crafting a self-serving narrative that they believe will be the most attractive to whatever audience they are focused on. Oh no. Oh no. Based on my interactions with Mr. Serrato and my review of several of his videos, which he probably only watched a few seconds of, I quickly concluded he was not acting in good faith and that there was no reason to continue engaging with him regarding Laura's case. And as it turned out, Laura lost everything, including all of her appeals, so really his whining doesn't matter. Instead, my impression was that Mr. Serrato was not a serious individual. I think, didn't he accuse Rachel Juarez of the same thing too? And that he had no regard for truth or honesty. For that reason, I generally declined any further interactions with him. Regarding Laura's request to renew the DVRO in this case, I obviously understood I was a witness to many of the events on which her renewal request is based. For that reason, I submitted a supporting declaration at the time Laura filed her request to renew the order, but I did not appear as her counsel of record. Because I am licensed to practice law in both California and Arizona, I know each state has different rules limiting a lawyer's ability to represent a client in a matter where the lawyer may be a necessary witness. In fact, Arizona's ethical rule on that issue, ER 3.7, expressly forbids lawyers from acting in a dual witness advocate role, period, without exception, whereas California's version of Rule 3.7 is more lenient. California expressly permits lawyers to occupy that dual role as long as the client gives informed consent. For that reason, in prior cases, when I have acted as counsel for a party, I have always moved to withdraw from any case where it appeared I may be a necessary witness. Here's just one such example from a case called Eccentric Ventures, LLC versus Mediolex Limited. All these X's. Is this about adult content? In that case, I was initially counsel of record for the plaintiff. However, eventually it became necessary for me to testify as a witness at trial. For that reason, I moved to withdraw from the case. The court granted that request and held my actions were entirely proper under the ethical rules. We're trying to build the case that he's super ethical, and Omar is not. But of course, his unethical means of claiming he's ethical and Omar is not ethical are not ethical. We'll skip over that entry. You can see it there if you wish. I'm aware California's version of Professional Conduct Rule 3.7 is far less restrictive than the Arizona equivalent. Specifically in California, a lawyer may ethically represent a client in a matter where the lawyer is also a necessary witness. The only requirement is that the client must give informed consent. He's trying to open the door to walking in to being Laura's counsel. That's what's going on here. He wants that to happen, I think. My opinion. In this case, Ms. Owens told me she was willing to provide informed written consent to allow me to represent her while also acting as her counsel. See, there we are. Ha! I'm prophetic. However, under the circumstances, I felt the best option was to allow Ms. Owens to file the renewal request on her own, with my support limited to the role of witness. The situation changed after Mr. Marraccini retained Mr. Serrato as his counsel, because David was so butthurt with how with how Omar has wiped the floor with him. Prior to this, Miss Owens did not know whether Mr. Marraccini intended to challenge the DVR renewal, and thus she did not know whether she was comfortable proceeding pro se or whether she felt the need for help from counsel. After Laura learned that Mr. Marraccini had retained Mr. Serrato, she asked me to represent her on a limited basis for the purpose of appearing at the Zoom hearing held in this case on August 15 of 25. Because that hearing was non-substantive and did not involve any witness testimony, I agreed to appear remotely on Laura's behalf at that time. Several days later, on August 18 of 25, I had a lengthy phone conversation with Mr. Serrato. According to my phone records, the call lasted 66 minutes. Also present on the call was a lawyer named Rachel Juarez, who has not appeared in this matter, but who I understand is also representing Mr. Marraccini in some unknown capacity. Well, we know what it is now, and she's co-counsel, so that's not a secret anymore. During this discussion, Mr. Serrato and Ms. Juarez told me they believed I should not continue to represent Ms. Owens for various reasons. Among other things, they argued I had a present conflict of interest with Ms. Owens because last year Mr. Marraccini filed a complaint against me with the State Bar of Arizona, which related to the same events at issue in this case. Mr. Serrato expressed his belief that because Mr. Marraccini accused me of misconduct in Arizona, that somehow created a conflict with Miss Owens in this case, which made it impossible for me to represent her. I told Mr. Serrato I strongly disagreed with his analysis. Without belaboring the details, no, heaven forbid there be details, David. My goodness, you certainly like to bloviate forever, but heaven forbid you actually provide actual facts or details. Your filings seem to have a problem with not being based in law or fact. as we saw in the last case. I explained to Mr. Serrato that I saw no conflict at all, actual or potential, between myself and Miss Owens with respect to this case. On the contrary, I saw our interests as entirely aligned and consistent. Not in conflict. I'm sure he did see their interests aligned. They were both self-serving interests for Laura and David, respectively. The bottom line is, I firmly believe Mr. Marraccini broke the law. Bullshit. He committed a crime. Bullshit. And he violated this court's order to such an extent that the relief Laura is seeking in this case is factually and legally proper. Double bullshit. This is true regardless of any other allegations about Laura's conduct in any other area. If that's convenient, let's leave those out. That she's facing 7 felonies for being a fraud. Oh, it's outrageous. I do not agree that Mr. Marraccini's allegations against me, which I perceive as frivolous, having any bearing at all on my ability to represent Laura in this case. In short, Mr. Marraccini has accused me of engaging in witness tampering, which he did do. That's what calling the police on someone and threatening them that they'll be hauled away when they have a valid subpoena from the court in which they were called to appear. That is textbook witness tampering. In short, Mr. Marraccini had accused me of engaging in witness tampering because after I saw him violate this court's DVRO in Arizona, I contacted law enforcement to report what I believed was the commission of a federal crime. But none of them saw it that way because obviously they didn't see it that way, and the judge who had issued said subpoena didn't see it that way either. By retaliating against me with a bar complaint based on my decision to contact law enforcement, I believe Mr. Marraccini has committed a further federal criminal act. And here we have a bastardization of 18 USC. Oh my God, what a dipshit. I'm not even going to read it. You can read it there, and that comes from Cornell Law. Who cares? For that reason, among many others, he's ridiculous. He's ridiculous. I think the context of 18 USC does not apply in this case. Anybody can file a bar complaint against another attorney. That's just the way it is. It's not a federal crime to use that system. And of course, with the number of complaints David has received, he is being investigated for misconduct. And hopefully, with any luck, such investigations will take place in California as well. And then the double jeopardy of losing a bar license in 2 states can take place, because I believe David should be disbarred. He has no business practicing law. He's a terrible attorney. He's an equally worse person, in my opinion. So time for him to work for Home Depot and lay down flooring tile for his mother. Oh, wait, he's already done that. Maybe he should just work for Home Depot. He could give advice on how to lay flooring tile. For that reason, among many others, I firmly rejected Mr. Serrato's argument that it would be unethical or improper for me to continue representing Laura in this matter. Nevertheless, in an abundance of caution and with a goal of reducing the contentiousness of this case, bullshit. He wants this to be as contentious and expensive for Mike as possible. This is all about being vindictive and running through money. After discussing the situation with Laura, I decided I would continue to participate in this matter as a supporting witness, but I would not act as Laura's attorney in any capacity regarding the case, other than, in the opinion of this commentator, ghostwriting all of her filings for her. That's just my opinion. I called Mr. Serrato to inform him of this decision on August 16, 25. According to my phone records, that call lasted 16 minutes. During the call, I told Mr. Serrato that I no longer represented Miss Owens with respect to this case, and that I would not appear as a lawyer on her behalf at any future hearings. I also told him that I would continue to participate as a witness, but beyond that, Laura would be representing herself, and that he should contact her directly if he had any further questions about the case. Following our telephone discussion on August 21, 25, Mr. Serrato sent me an email asking me to confirm in writing that I no longer represented Laura in this case. Mr. Serrato's message is shown below. There it is. Dated Thursday, 8/21/25, 3:39 p.m. I immediately responded to Mr. Serrato's request with an email shown below. 8/21/25, 10:08 p.m. That's not exactly immediately. That's 7 hours later, almost. 6 and some change. So much for immediate. Immediately would be within the hour, in my view. And we talk about e-service, he blathers on. Unfortunately, although I believed I sent the email to Mr. Serrato shown above, the next morning I saw the email to Mr. Serrato appeared to still be open and unsent on my desktop, although the email does appear in my sent message folder along with other outgoing emails. He doesn't show the outgoing emails. That's a convenient excuse. We know someone else who liked to show their email inbox and sort of allege things about their emails. Based on this, it was not clear that the message was sent or delivered, so the following morning I sent a shorter second email, which again confirmed I no longer represent Laura, blah, blah, blah. So we start with like 3 paragraphs. Well, yeah, let's just say 3 paragraphs. We'll round up. And then we go with a very short, yeah. And as all of you know, when you hit something and it's sent, it goes into your sent box. There's no, it appears as a draft and it appears in the sent at the same time. I think he's lying about that. And of course, he didn't show. He gave no evidence of his sent folders. So maybe he was intoxicated. Maybe he fell asleep eating mac and cheese. We don't know. But I don't think he's being very honest in his representation here. A few minutes later, I received a reply from Mr. Serrato confirming he received my email, blah, blah, blah. Based on these events, I was shocked when I learned that on August 25, Mr. Serrato filed a motion to disqualify me from acting as Laura's counsel in this case. One of the many reasons I decided not to continue representing Miss Owens was to avoid even the mere appearance of impropriety, even though I believed Mr. Serrato's conflict of interest arguments were spacious. Yeah, I'm sure he's so worried about appearance of impropriety. Although we just happened to get a DUI offense within minutes of Laura's house. Go figure. I also did not want to burden this court with needless motion practice over the propriety of my participation. The simple fact is that regardless of whether I act as Laura's counsel of record, I am still a percipient witness in this case. Thus, even if Laura represents herself without counsel, I can and will tell this court what I saw and will testify about the events leading up to this point. For that reason, I did not think remaining as Laura's counsel of record was sufficiently important to justify challenging Mr. Serrato's position, even though I disagreed with it. Raise your hands if you'd like to see Gingerbread being cross-examined by Omar. I know I would. It would be very entertaining for me. He'd probably try and make objections from the stand. Oh, the images I conjure up of Jingy on the witness stand. It is clear to me that Mr. Serrato intentionally lied to this court about the facts and has attempted to actively mislead this court about the truth. Yikes. This conclusion is based on, among other things, the extremely careful wording shown below, wherein Mr. Serrato claims that I told him, both verbally and in writing, I do not intend to represent Laura Owens in these proceedings. I believe Mr. Serrato used this line to make it appear that he did not completely lie to the court. After all, he kind of mentions the written and verbal discussions between counsel, which is good, but rather than telling the court what I actually said, that I no longer represent Laura in this case, Mr. Serrato changed the quote to make it appear far more uncertain and unequivocal. Mr. Serrato vowed that I am continuing to represent Miss Owens in this case, and that I have somehow refused to clarify that the attorney-client relationship has actually been terminated. Based on my past dealings with Mr. Serrato, I have no question that he intentionally gave this court a false and misleading impression of what occurred, and that he did so for the specific purpose of filing a pleading that contains serious allegations of misconduct on my part, which Mr. Serrato knew were entirely false. I'm also confident that Mr. Serrato did this for one primary purpose, to give his YouTuber friends fodder to create additional videos attacking me, exactly as Mr. Serrato has done over and over and over during the past year. Oh, boo-hoo. Wah, 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 wah. People don't like you, Jingy. They're allowed to. That's your problem. You don't have to go seek them out either, you know. According to YouTube, Mr. Serrato has posted more than 400 videos on his channel. Well, they aren't all about this. Although certainly not all of these videos are focused on myself or Laura, a large number of them are, and virtually every one is insulting, disparaging, and in many cases defamatory bullshit. In many instances, Mr. Serrato insults my unusual French-Canadian surname, referring to me as Dingus, Jingy, Gingerbread, and often Douchebag or Douche Canoe, or my personal favorite,
The fucking Douche Canoe.
I kind of wish it said DUI Douche Canoe. That's my favorite right now. DUI Douche Canoe. In these monetized videos, Mr. Serrato frequently steals photographs of me from my social media pages. That's not stealing. It's public. Anything on social media is public, David. You know this. If you really are a free speech internet attorney, which I'm not so sure anymore because you don't seem to know these things. It should be obvious. It is a public forum, David. And he uses them without my permission as part of his video thumbnails. Just a few examples are shown below. It's called fair use, David. You should know about that too. Time to revoke your bar card. And look at these great, very high quality, but black and white images, unfortunately. I'm sure they look much better in the real world. We've seen these. These are in other places. In addition to personally insulting and attacking me, Mr. Serrato also frequently publishes scathing, exceptionally cruel personal attacks against my girl, Laura. Oh my God, I might slip into the southern voice. Okay, I'm going to resist that temptation. Often portraying her as being physically assaulted by Mr. Eckert. Mr. Serrato also frequently uses cruel, humiliating images of Laura crying, juxtaposed with the smiling faces of his friends taking pleasure in Laura's pain. Yeah, she's only in pain when she gets caught, and she's being held by police for committing fraud, perjury, and tampering with evidence, and they are raiding her house. And that's not even pain. That's just screaming and yelling she's not getting her way. In my 25 years of practice, I've worked on a large number of major important cases in both state and federal court. I'm very important, many of which were so important they were extremely contentious. And I've litigated cases before the California Court of Appeals. You know, that's when they got the fancy rooms and all the shiny wood. Lots of shiny wood. I like that shiny wood in there. Very shiny. Lots of brass, too. Lots and lots of brass. Very fancy flags behind the judge. I like that Court of Appeals. I haven't won many there, especially the most recent one with Laura. We try to take that all the way to Supreme Court, even the Supreme Court of the United States, Scottish. No, we did. The appeals court of Arizona didn't like me. They wouldn't give Laura a chance. It was a shit show, and oh my goodness. They told me my things were based in law or fact. I'm so delusional. I don't know law from fact, and I don't know fact from law. It's just the way it is with me. I just can't help it. I'm a douche canoe attorney and one who likes an ounce of bourbon, or maybe it's scotch. I don't know. It's some sort of spirits, but. Well, I've talked about how I put it in my coffee cup when I'm on YouTube. Oh, nope, no one's supposed to know that. That's just my opinion. And keep my fat cat away from my coffee cup. But I did obtain some favorable positions that I want to brag about, but I don't brag about them right here at this point in time. But based on my experience in handling a large amount of contentious litigation, I am used to seeing rude, disrespectful, unprofessional conduct by opposing counsel. Oh, okay, I need to stop now. I should have started with that. It would have been funnier. It's thankfully rare, but it is something I've dealt with many times over the years. Mr. Serrato's conduct is, as described above, is markedly different. His actions are not merely unprofessional. They're cruel, malicious, threatening, and personally vicious to a degree I've never seen from any lawyer ever before in my entire life. Ever in this country. Oh. And he declares this, rather stupidly, under penalty of perjury. So maybe we can get Dingus the Douche Canoe on some perjury charges in California as well. Just like his former client. Wouldn't that be amazing? And that's dated September 12 and signed in his blue Crayola marker by David S. Gingras, Esquire. All right, so that concludes this little reading and this filing. We'll get to more in coming days. So stay tuned, everybody. Till next time.